Welcome back to Good Law, Bad Law. My guest on today's episode is Katie Fallow. She's an attorney with the Knight First Amendment Institute at Columbia University in New York. And we're talking about President Trump and his Twitter account. And we all know that President Trump is famous for his tweets, sometimes infamous for those tweets. But what is perhaps not something we focused on near enough is the fact that when the President of the United States uses Twitter, he's really using it in a way that has to comply with the First Amendment. So the question in this lawsuit that we're going to be discussing today is, can the president block Twitter users whose opinions he doesn't agree with or whose criticisms of him on Twitter he just doesn't want to hear? Or is that a violation of the First Amendment? Stay tuned for a very interesting episode. I know you'll enjoy it. My guest today is Katie Fallow. Katie is a staff attorney with the Knight First Amendment Institute at Columbia University. Katie, thanks very much for being on the program.
Oh, it's my pleasure.
So we're going to be talking today about a lawsuit, Katie, that you've been involved with. It's a fascinating case involving President Trump and his use of Twitter. Give us just a thumbnail about what the case is about before we get into some of the details of the lawsuit.
Sure. So we at the Knight Institute represent 7 individuals, ordinary Americans across the country who were blocked from the president's Twitter account, the @RealDonaldTrump account, after they posted critical replies to some of his tweets. And our lawsuit claims that the blocking of our plaintiffs based on their viewpoint violates the First Amendment.
And the reason it does is because, or the argument that it does is because this is the president, this is a public forum, the way he's using it. Is that right?
Yeah, I mean, we have 3 basic claims. The first is that the president is using his @RealDonaldTrump account as an official account, and it is a public forum where people can reply directly to the president and can reply directly to each other in this forum that's created via his Twitter account. And there's longstanding precedent that the government cannot exclude people from a public forum based on viewpoint. And we liken it to a virtual town hall where, the president, like a city council member, stands at the front of this virtual town hall and he speaks, and then members of the audience, which is the vast number of his Twitter followers, are able to speak to each other and to him. We also have 2 other claims that are not just public forum claims, but we argue that because this is such an important source of information about the government, to block people from accessing this important source of information based on viewpoint violates the First Amendment, and that it also interferes with their right to petition the government for redress of grievances under what is called the petition clause.
Right. Well, this is, President Trump, and before he was president, just Donald Trump, got a lot of attention for his Twitter, but I don't know that this is the kind of attention he ever thought he would get. But it's an important issue when, as we're recording this episode, Mark Zuckerberg, the head of Facebook, is in Congress answering questions about Facebook, another of the big social media platforms, and the role of these social media virtual town halls, as you call them. And what are the implications in terms of privacy? What are the implications in terms of the First Amendment? I want to take a deeper dive into the case and these issues, but first I want to try to learn a little bit more about you and the Knight First Amendment Institute at Columbia, my alma mater. Tell us a little bit about what the Knight First Amendment Institute does and how you came to work there and some of your own background.
Sure. The Knight First Amendment Institute was established in 2016 as part of a joint venture between the Knight Foundation and Columbia University. And the idea was to create a nonprofit advocacy, research, and public education organization at Columbia that is focused broadly on defending and preserving First Amendment freedoms in the digital age. Part of the impetus was the recognition that because of the financial stress on traditional newspapers and news organizations that has been brought about by the digital age, there was a concern of a potential dearth of resources. You used to have newspapers, the New York Times, Washington Post, fighting the really big First Amendment cases, and there was a concern that as traditional news outlets experience greater financial strain, they would not be able to devote those resources. So to create an independent advocacy organization. And also in recognition of what you've alluded to, which is that there have been such enormous changes that have come about because of social media and the internet and the lightning speed advances in communications that create new First Amendment problems and a concern that we apply, how do we apply traditional First Amendment doctrines to these new forms of communication?
And what about yourself? How did you come to be associated with it?
So my own personal background is I was a partner at the law firm of Jenner & Block in Washington, D.C. for 15 years, where I had a media law practice that combined, represented a number of national organizations in challenges to restrictions on, for instance, violent video games or regulations of the internet and libraries, and also defended against defamation claims on behalf of organizations like the Huffington Post. After that, I was the deputy director of the Bureau of Consumer Protection at the Federal Trade Commission. And then in 2016, coincidentally, not because of this job, but my family moved to New York and had the good fortune of landing here, which has been really an exciting way to combine my background in First Amendment media law and working in a nonprofit and also in a university.
And to be in a great campus around Columbia, Morningside Heights. The Knight Foundation, is that now I know there was the Knight family that owned once upon a time long ago, and maybe still today, a group of newspapers. There was the Knight Ridder Company. Is that the same family?
Yes.
Okay.
Yes, and the Knight Foundation is located in Miami, Florida, and they do a lot of great work, particularly in supporting journalism and free speech initiatives. Right,
and Columbia, of course, in part famous for its great journalism school. So, there's a great tradition there. And I, in my time at Columbia, I was editor of the Columbia Spectator. So, my wife and I were watching this movie that's out now called The Post, which is about the Washington Post and its involvement in the Pentagon Papers case in the early 70s. And there's these scenes where the presses are rolling out the editions of newspapers. And, to think that to me, it doesn't seem like that long ago that when newspapers really were so important in the delivery of news and information. Now everything is digital. So the role of Twitter and Facebook and other sources of information, as you say, in this digital age, become so important, and we have to almost rethink the way we apply the First Amendment and how challenges to the First Amendment come up. So. Tell us a little bit about the background of this case now, Katie, and how I know there were 7 individuals you mentioned who were blocked from President Trump's Twitter. First of all, give us a little bit of the flavor of who some of these people are.
Yeah, I'm happy to. I just will say one thing is coincidentally, I haven't seen yet the movie The Post. The Supreme Court scenes in that movie were actually filmed at Low Library, where
Oh,
the
wow.
Knight Institute's offices were. And so some of us, I guess at least one person, not myself, from our office got to meet Meryl Streep. So that was very exciting.
That's great. It is a very good movie, by the way. I recommend it.
Yeah. No, I know. I definitely want to see it. Yeah. And so in terms of our plaintiffs, we started hearing about the case just by way of background. There was a general knowledge at the time that the president was inaugurated, that he was going to I guess there was a question: is he going to continue to use his @real Donald Trump account, which he did, as you mentioned, establish before he was president?
Right.
Is he going to still use that, or is he going to transfer to the pre-existing presidential Twitter account, the @POTUS account? And there were some news reporting at the time that he was inaugurated that there were some people that were blocked from his @real Donald Trump account, but who had been blocked when he was not yet a government official, not yet the president.
By the way, Katie, he's not the first president to use Twitter. I mean, I know Barack Obama as president used Twitter, but if I'm not mistaken, used the POTUS, POTUS, President of the United States, sort of the official Twitter handle.
That's right.
Were the president. So as you go through this, I think we should differentiate and what makes this issue as a First Amendment issue even an issue, because President Trump is using the same Twitter account he had used before he was president.
Exactly, and that does become a main issue in the legal arguments of the case. But I do think that it is an important background, which I think everybody has experienced in real time, which is that there was a question of is the president going to continue? Is Donald Trump going to continue to use Twitter in the same way that he did before he was president? And I think President Obama did have the @POTUS Twitter account, and I believe there's also an @White House Twitter account, but used it in much more of this sort of traditional, frankly, more sterile way, but also sort of seemingly more official way that he would make pronouncements and not use it as a sort of direct way to communicate with the public. And then, as we've all seen, that President Trump has actually used his Twitter account as almost his primary means of communicating to the public and hearing from the public and creating a public discourse about his pronouncements. And, I think, if anything, more than almost most people, has demonstrated the power of social media and Twitter as a tool of communication between public officials to the constituencies.
And also he's used it. I think part of what's different about the way he's used it is just some of what makes him different too. I don't think many politicians would say in any form of communication things in quite the way that Donald Trump would say them. I mean, he will call people names. He will discuss today. He's tweeting about impending missile strikes against Syria as retaliation for chemical weapons. I don't think there are very many politicians who would tweet or put in a speech in the way he has, so that when people hear or read or view these things online, they say, oh, no, he didn't say that. Oh, no, he didn't. I mean, I think that's part of, I'm not celebrating that or even criticizing that, just observing that that's something that is also different about how he's used Twitter. It's not like press releases from the White House. It's really his personal, but now as president, sort of official running commentary on everything and anything.
Absolutely. I mean, different people obviously have different reactions to his tweets and the level of decorum, but I think almost everyone would agree now that they are certainly powerfully effective communication tools that he is using, that I think people didn't maybe underestimated sometimes or didn't understand the import of them as a way of communicating and governing. And, and saying things in ways that people never thought, that a president would speak. But anyway, just go back to our plaintiff. So about a year ago, we became aware through news reports and just being on Twitter of a number of individuals who were being had blocked by the president. So these people would tweet out, look, I was blocked by the president, and show if you are blocked by someone on Twitter, which means that they, you follow the way that Twitter works. If people are not aware, and I frankly wasn't as aware because I was not an active Twitter user until I became involved in this case. You can follow anybody once you establish a Twitter account, but if that person blocks you, then you cannot see their tweets, and if you try to, you'll get a little screen that says you have been blocked by this person. And you also cannot, the way that Twitter works is if you have a Twitter account and you follow someone else, and you see their tweet, you can reply directly to them, and your replies then appear in these kind of comment threads that are, are listed underneath the original tweet. And so if you, click on one of @real Donald Trump's tweets, you'll see underneath there are thousands of replies from people, real and some bots, but also people all across the country and the world replying to each other and then replying to the president and having them these conversations in these comment threads. So we started seeing a number of individuals, and we got in contact with them, and our 7 plaintiffs, for instance, include a writer and law graduate, a comedy writer, a medical resident, a professor of sociology at University of Maryland, a police officer and veteran, and a political activist. And so these are sort of ordinary Americans across the country who were blocked because they replied directly to a tweet from the president. And it is the way that also Twitter works is when you reply directly to the president, and because there are thousands or tens of thousands of people who are replying directly to him, the reply tweets that are the most popular, meaning they get the most likes or the most retweets, tend to appear at more towards the top of the comment thread. So presumably, and it's fair to infer that the president saw their reply tweets and then he personally blocked them. And when we first started hearing about this, we thought, well, what kinds of things are they saying? Or presumably the president or the White House would say, well, these people were really insulting or they were using profanity. But really, if you look at our plaintiffs, the kinds of things they said were mostly critical in a political way. For instance, one of our plaintiffs, Rebecca Buckwalter, the president had tweeted something like, if I had relied on the fake news of the mainstream media, I would have had zero chance of winning the White House. And Ms. Buckwalter replied, to be fair, you didn't win the White House. Russia won it for you. And that her tweet got a lot of likes and got a lot of retweets. And shortly after she replied, she was blocked by the president.
So there's no profanity or name calling or anything offensive in what she said. You can agree with it or disagree with it, but it's a criticism. It's obviously a criticism of what he said. But why? Let's get into what some of the First Amendment issues then are. Now that we have this really juicy example, so what's wrong with President Trump saying, "Hey, on my Twitter account, I don't have to listen to that kind of criticism. I'm blocking her. I don't like that."
Yeah, right. And I mean, certainly people, that is one reaction. So first of all, to be clear, we think that, private individuals can absolutely block people if they want to from their social media accounts, their Twitter accounts. But when it's a public official who is operating an official account, then the pre-existing rules of the First Amendment must apply. And just as a public official who was hosting, as I've mentioned before, an open town hall meeting that was open to all constituents equally and was made available, they allowed audience participation time and the ability to respond. it's a longstanding rule that the public official cannot kick someone out of that town hall because they don't agree with their viewpoints. And that goes to the sort of bedrock First Amendment principle that speech should not be suppressed based on viewpoints, because we want to have a free and open discourse, especially in the area of political discourse, which this unquestionably is. Now, the government, in response to our claim, has, its main defense is what you mentioned, which is they say, look, this isn't his official account. This is at Real Donald Trump. He established it in, I think, like 2012. He used it a lot before he became president. And the First Amendment only applies when a government actor in some way suppresses or restricts speech, and that's known as the state action doctrine. And so the government in our case argues there's no state action here. The First Amendment doesn't apply because this is his purely personal account.
Yeah, I mean, that's remarkable, Katie, because I've read the complaint that you filed in court, and we'll post actually a link to the complaint. It's a fascinating read for all the details behind this and information about the other individuals who are part of this lawsuit. We'll post a link in our description for this episode so people can get access to it. But that's a laughable position to take, isn't it? Because although it still is the same account he used before, there's no question that as people have raised issue with and concerns about and questions about his tweets and asked, hey, is this just Donald Trump talking or is this President Trump talking? He has said, and his aides have said over and over again, these are official statements by the president. When he tweets something, that's the word of the President of the United States.
I mean, certainly, as you can imagine, we completely agree with your assessment that it's laughable. But, in all seriousness, I do think that the record in this case, which has been built up as this case has proceeded, is absolutely clear that the president and the White House are using this account as an official account. They're using it as equivalent to, if not a substitute for, the @POTUS account. And that is made clear in, as you said, first of all, that the president routinely uses the account to make official announcements, often for the very first time, like he announced the appointment of a new FBI director last summer via his @Real Donald Trump account. He made the initial announcement about his ban on transgender individuals serving in the military through the Twitter account. And DOJ itself has represented in a number of proceedings, meaning Department of Justice lawyers in other cases have said the statements on his Twitter account are to be considered official statements of the President of the United States. And the courts, in some of the challenges to his immigration ban or the transgender serving in the military ban, have treated those tweets as official statements of the United States, of the President of the United States, that have legal effect. I also think it's important to note that contrary to the DOJ's claim in our case that this is a purely personal account, the record shows that the president uses White House staff, including Dan Scavino, who is his director of social media, and other members of White House staff help him administer this Twitter account. So all of those going together, our argument to the court in our case has been that the record establishes without question that this is functioning as an official account, even if it's an account that he brought in with him before, that he established before he was president.
So if he had kept @Real Donald Trump, which was his Twitter handle before he became president, really as a separate account, was only tweeting out personal things or things that didn't have the substance of official business of the president, I assume under the First Amendment that could be looked at differently. He could block or follow or do whatever he wanted with that.
Yeah, I mean, I think absolutely. Public officials like the president and others are have they're in charge of how they use their social media accounts. And so I think in these kinds of cases, if there's a question of whether or not there's state action or whether it's an individual account versus an official account, the courts can evaluate it the way that they evaluate any other kind of factual question. You look at the record evidence and the totality of the circumstances. How is this account functioning? And then I think it's important that you apply this functional as opposed to a formalistic, analysis here. But that makes sense because it's just as if someone, public official uses their private email to conduct government business. It doesn't mean that they're relieved from all the obligations that they would have. You look at what they're using it for and how it functions rather than what it's called.
So, I mean, it seems like in trying to figure out where this is all going to go and with this lawsuit and these claims, it doesn't seem like the government has much of an argument that this is personal versus official. Where do you see the case proceeding from here? Is the focus at this point more in terms of what should be done about the situation now that, I mean, the complaint is very detailed in showing the kinds of tweets he issues and their connections to official business and lays out what it means to be blocked. And you've got the argument of a that this is a virtual town hall or is a public forum as in the language of First Amendment law. So where do you then see this going? This case playing out in the court?
Yeah, well, I mean, first, just to be clear, that the request, what we're seeking in our lawsuit is an order requiring the president or the White House to stop blocking our plaintiffs. So we're not seeking any money or any kind of money damages, but just an order requiring him to unblock the plaintiffs and a declaratory judgment that it violates the First Amendment for the president to block people from his Twitter account based on viewpoint. And then right now we have filed a motion for summary judgment. The government has filed a motion for summary judgment. We had a hearing before the court the Southern District of New York trial court, Judge Buchwald. She had a hearing in March, and we are waiting for her to rule on our cross motions for summary judgment. As I said, I agree with you on the assessment of whether it's an official or a government account. The government, also has a couple of alternative or subsidiary defenses where it argues that even if this is state action such that the First Amendment applies, they still really want to hammer home on this idea that this is his own personal account. And their argument is it's not a public forum and it's not subject to this requirement that government officials stay neutral on viewpoint because it really is just the president's speech. All this is involved is his ability to say what he wants and to hear from the people, to pick and choose who he hears from. And our response is that both either misunderstands or mischaracterizes how Twitter works and also inappropriately substitutes this idea that public officials should be able to just pick and choose who they hear from versus government speech. It is without question that when the government speaks or a public official speaks, again, going back to this town hall analogy, the city council member absolutely can get up in the council meeting and say whatever they want, and they're not required to be neutral as to what viewpoint they express. They can express their viewpoint. And so we're not in any way seeking to control what the president says, but our argument is that these comment threads, the ability to reply and those comment threads that appear below his tweets, that's the equivalent of the audience portion of an open town hall. And just as that city council member couldn't kick someone out because they disagreed with him or her, the president shouldn't be able to shut down the replies of our plaintiffs, our clients, or anyone else because he doesn't agree with their viewpoints.
Yeah, see, the issue of blocking someone on Twitter, and I know you touched on this earlier, there is the analogy to the town hall from the perspective of the speaker here, Donald Trump as president. I mean, there's nothing about what it is at issue in this case, as I understand it, that limits or seeks to limit what he can say on Twitter. He can say whatever he wants within the limits of Twitter, 140 or 280 characters. But it seems like the real issue is an individual's access to what the president is saying. And because when you're blocked, it's not only that your comments can't get into the thread in responding to that tweet, you can't even see what the president has said in that tweet. You're blocked from even seeing it. So
exactly.
Help us. I mean, can you help me understand that? Because it seems like we're focusing on what impact this has on Trump or on the president or on any public official who's using Twitter for official business. But it seems like the real impact is on the citizen, on the person who has a right to not only express themselves in response, but also even to just get access to that information.
Yeah, I mean, I think they go hand in hand. In order to reply directly to the president, speak in that forum, and be able to talk with other citizens about the president's statements and policies, you need to be able to see what the president said. And so if you're blocked and you can't see his tweets, you can't reply directly because you don't know what he said. Now, people have made the point that there are ways to view his tweets otherwise. So you could log out. Anyone who even does not have a Twitter account can go onto Twitter and see the president's tweets. But if you are a Twitter user and you are logged in as yourself, the way that people always are on their phone or on their laptop, you've logged in and the computer recognizes you, you wouldn't in the normal, use of that, be able to see his tweets. You could log off and log in, or just go in through a general browser and see his tweets, but then you wouldn't be able to reply directly. So I think both go hand in hand. Some people have argued, well, there's no right to access information in one particular way, but our response is here. I mean, really, when you're looking at First Amendment cases, you're always sort of weighing the impact on someone's speech versus whatever the government interest is. And, in our view, there is no legitimate interest in suppressing speech because it's critical of the president. I mean, that's just part of the tradition of having, vigorous and sometimes unpleasant debate, but that's at the heart of our First Amendment tradition, so that the government interest here is not legitimate at all, and there is a burden on your speech of the ability to participate in this forum.
Is the government making any claim that there is a right of a public official not to hear a viewpoint that the official doesn't want to hear? In other words, are they
Yes.
arguing that he has a right? Not because it may be his personal Twitter, but because even as a government official, he has the right not to hear criticism.
Yes. In effect, they are. They're saying just because the president is the president doesn't mean that he doesn't have the rights, or basically what they liken it to, that a public official who attends a convention or a conference isn't required to speak to every person who comes up to them equally. They are allowed to walk away from someone, a critic or not a critic, just for whatever, because they have associational rights. Certainly that's true in a day-to-day basis. No public official has to speak to one or another person.
But you're hosting a forum, which is really what
from if you have a meeting room and you allow everybody in, except for the people who criticize
I'm
you.
busy now. Right. Well, that's what's different. Is choosing to host a forum. In this case, it's a digital forum called Twitter. What about that is different, or makes this different?
Well, I think sort of two things. One is that it is his Twitter account is generally open to the public without any kind of restrictions. So it is creating a space where people, individual citizens, can participate. It's not with thousands or tens of thousands of other citizens. So that's different from having sort of a one-on-one meeting or a kind of closed-door conference. But the other, important factor here is that the president, by blocking people or not blocking people, acts as a gatekeeper as to whether people can participate in that forum at all. So essentially, if you allow everyone in, but then you exclude a few people or some number of people because of their viewpoint, you're acting as a gatekeeper, not as an individual participant, as the government has tried to argue.
And it's, I think, especially extraordinary in this case with this individual, too, because many commentators have tried to pick apart his tweets and try to figure out, is he really doing this himself, or does he have an assistant who's tweeting for him? And I think most people have said pretty clearly he's doing a lot of this himself, which raises the extraordinary picture of, first of all, an individual citizen directly having the opportunity directly to communicate with the president, and on the other end of that, the president having the ability to hit the block button and actually block out a citizen because he doesn't like what that citizen is saying. I mean, it really is extraordinary.
Yeah, I absolutely agree, and it is very interesting what this case has shown. First of all, it is the government has admitted that the president himself personally blocked our plaintiffs. Mm-hmm. And on the other side of that,
that was admitted in the case.
Yes, the government and we filed a joint stipulation of fact, which is available on our website, and it's pretty interesting. And some of the interesting facts were that he personally blocked people, and also that although he personally blocked people, that he does have staff members who help him write tweets, post tweets, and have the ability to block and unblock people. So it's not just a one-man operation. At the same time, he is doing some of it himself. And on the flip side of the blocking, and we have posted some testimonials from our plaintiffs, really was this sense of how sort of surreal and upsetting it was to be blocked personally by the president of the United States because you said something critical that, several of the plaintiffs saying, it just seemed not what they expected from America, in essence, and that they felt strongly, but he's still our president. And I think this real sense of that the American tradition is that you may criticize your public officials, even someone as powerful, or especially as someone as powerful as the president.
Right. Well, in the immediate business of this lawsuit, it sounds like we're waiting for the judge to rule on these cross motions, and really it sounds like that should decide the case. I mean, once the judge,
yes,
this isn't a case that's going to go to a jury to find facts. You've already agreed on facts, and it's now just up to the judge to apply the law and say, yes, what does the First Amendment require or allow here? Is that right?
Yes, okay. Absolutely. And then, I would expect that however she rules, that the case will most likely be appealed to the Second Circuit Court of Appeals. I will I should note that in the case, the government also argues an immunity defense, the argument that courts lack jurisdiction or should withhold jurisdiction from issuing an injunction, an order against the president specifically. But in this case, what we have argued and discussed with the judge is that to the extent that there's any concern about a separation of powers, concern about a court ordering the president to do something, Mr. Scavino, Dan Scavino, the head of social media, is also named as a defendant in the case, and so the court could require him or anyone else who has, the ability to unblock the plaintiffs, and that would be sufficient. But that whole argument raises a whole host of other issues, which would probably take another podcast because they involve, cases from the 1860s. So.
Right. Well, but I'll say this and maybe rounding out our conversation just on this topic, because hearing you say that the government here, the president, the Department of Justice is arguing that they are immune from this type of claim, that the courts can't basically tell the president what to do with his Twitter account, seems somewhat related to some of the issues we've seen in some of the big First Amendment cases, and not in very recent times, but I'm again thinking of the movie The Post and the Pentagon Papers, and in that case, the government telling the major newspapers of our country, the New York Times and the Washington Post, that they can't publish certain sensitive material just because the government says it's sensitive material, and we know how that turned out. But that was again in the days of newspapers, not in the days of mass digital communications with instant communication across the country and indeed across the world. You note that Twitter has 300 million users. It may even have gone up since this lawsuit was filed middle of last year. So I guess I want to try to zoom out from the case a little bit and ask you, where do you think the frontier is now with Twitter in particular and the First Amendment? This issue, raising a lot of important issues about what the government can and can't do in these public forums, or when Twitter becomes a public forum. But where do you see the frontier taking us?
Well, and we've always, said as we've pursued this case that although the president is the most, famous public official using Twitter, the principles that we're seeking to vindicate here apply to public officials across the country and at every level of government. And the Supreme Court just last summer in this case, the Packingham versus North Carolina case, which involved a different issue, but Justice Kennedy, who wrote from the majority in that case, really emphasized how important social media is in everyone's lives these days, and particularly said that Twitter is a way in which that public officials can communicate directly with their constituents and in which citizens can petition their public officials directly. So recognizing that, and in fact, Justice Kennedy said it, that in many ways, Twitter and other social media platforms have become the new equivalent of a public square where people are talking to each other and debating policies. And what he said in his decision and what the majority said is, for that reason, it's very important that we be very vigilant in applying the traditional First Amendment principles of viewpoint neutrality and protection of speech to this new realm of communication. So that it's not that all of a sudden everything's, off the table in terms of First Amendment principles. And then I think, just news reports, you see a lot of public officials maybe not having, members of Congress not having as many open town meetings or open meetings, so that social media becomes even that much more important. And so we think it's very important that, and again, what we're just seeking is a requirement that when public officials do have social media accounts, they not block critics, and that's both to protect the people who are blocked because they have a right to speak, but it's also to protect against creating kind of echo chamber where you only have people who agree with the public officials, only have their views reflected in the comments. You want to, just allow everybody to speak and allow public discourse to take its course
right.
as much
Let the
as possible.
better ideas win. Right. I think that's great. Well, listen, I will keep an eye out for the court's decision in this case, and we'll follow it. How can people who hear this podcast find out more information about your organization, about you? Is there a website you want to give us, or an email, or anything like that?
Yep. Our website is knightcolumbia.org, and that's KNIGHT Columbia, all one word, .org. And on our website, you can go to the cases section of our website and find our Trump versus Twitter case, a Trump Twitter case, and it has all of our pleadings, and it'll have updates as well.
That's great. Katie, thank you so much for being on Good Law, Bad Law. I really appreciate it. It was great talking with you.
Thank you very much.